Defense made a motion for a mistrial.
Prosecutor was up to some fuckery.
Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land, I'm the Moorish Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. The late evening U.S. people.
In the kingdom of refuse, where chaos reigns supreme, there dwells a wicked woman. She comes from a nightmare dream. She's the queen of the rubbish, with a heart black as coal, forcing tortoise slaves to fight under her control. She's the evil woman of an overlord, living in a trash dump. Her army marches forth to the beat of a war drum, with the cry echoing loud, a chilling, dreadful curse. You're not a nice person. Her reign, it grows worse. But amidst the chaos, a flicker of hope does gleam. A rebellion rising like a fiery stream. They'll defy her tyranny, they'll break her iron hold. For even in darkness, the light remains bold. In the land of discarded dreams, where despair takes hold, she commands her legions with a grip icy cold. Through the valleys of garbage, they march without a pause, forced into battles, obeying her wicked laws. She's the evil woman of an overlord, living in a trash dump. Her army marches forth to the beat of a war drum, with the cry echoing loud, a chilling, dreadful curse. You're not a nice person. Her reign, it grows worse.
Wow, there we go. I need to work on the fade on that ending. How we all doing? Good morning, good afternoon, good evening, good night, everybody, wherever you are, whoever you are, whatever you're doing, whoever you're doing it with, however good it feels, however many times you're doing it, etc., etc., etc. I'm just excited and ecstatic that you're doing it right here with me, Legal Vices, on my little old channel I like to call Legal Vices. It is the Saturday morning after the Friday night before. We're doing okay. It is bright and early. It's early. It's 10 a.m. because Friday night finished around 5 o'clock in the morning. So anyway, how we all doing?
I hope you like that intro. That was that's one of the new intros I was working on. I had to see. I had to manually do all of that. I haven't combined it all together in a single video yet. But that was the war tortoises. That's the name of that song. The war tortoises. I hope you enjoyed it. If you were one of the people here in chat talking about drama and BS and you weren't paying attention to the lyrics of that song, I feel sorry for you. I feel genuinely sorry for you. That's a hilarious song that I wrote myself. So we're here. We're talking about the What the Hales saga. We're talking about the third motion to recuse the judge. See, I'm not even good to do my merch. I should drink my coffee this way so you can all see the Legal Vices coffee cup there. I'm terrible at grifting, aren't I? You can tell, couldn't you? Right. So, let's see. One thing we're not going to do is that we're not going to shit stir anything today. It's not, as they say, not my circus, not my monkeys. So, yeah, that's all I'm going to say. Let's see. Born Sinner, we're not talking about what you see. This is the only time I'm talking about this. Born Sinner says, why do you think What the Hales copyright struck law tubers for having a different opinion than them? I don't know why. I don't see it. I don't look at it. I didn't see the copyright strike. I don't know what I heard. I haven't seen what the copyright strike actually says. I haven't asked anybody why they did it, why they didn't do it. It's not my problem. I don't care. It's not my problem. It's between whoever it's between is between David and it's between the Hales. I got nothing to do with it. And there's no reason for anyone else to make it worse, make it better. It's between them. They'll resolve it or they won't. Not me. I have zero problems with anybody. So not going to start. And that's really all I'm going to say about that because, not my place. The people involved can talk about the problems, can talk about the issues if they so choose. That's not something that happens here. Tammy Fayette with a $5 super chat. Toast for my dad. He would have been 84 today. Well, it's 10 a.m., so the toast you get is a nice coffee toast. Cheers to your dad. He did a hell of a job raising an amazing person. That's happy 84th dad. All right. So what we're going to be talking about again today is nothing else other than the respondent's third sworn motion to disqualify Circuit Court Judge Craig DeThomasis. Craig DeThomasis here is the problem. He's if he was focused more on being a judge and more on less on being a law professor or a holder of grudges, this would have been over and done with. It would have been out of the way. It would have been finished. It would have been fixed. And that would have been the end of it. But he's not doing that. He's not being a judge. He's being an advocate. He's being a butthurt person. He's letting people get under his skin that aren't even trying to get under his skin. He's taking everything personally. And again, the lectures from the bench. I cannot with the lectures from the bench. As I've been saying the past few hearings we've done, he's not holding hearings. He's holding talkings. It's ludicrous what this judge is doing. And that's what we're talking about. Jason J., member for 9 months, is possibly an Aussie raid coming in. Well, that's cool. Possibly an Aussie raid incoming. Thank you so much for being a supporter for 9 months. I appreciate that. Right. Oh, and again, I swear I'm not going to be dragged into this, but that was a comment I wanted to make. Someone was like, I didn't see where the comment was, but someone was, when someone makes a copyright strike, law tube comes together, but not this time. You know what? I wasn't asked to. Nobody asked me to. So, if people need help, they'll ask. If people want my support, they'll ask, and then I'll decide whether or not. Nobody's asked. So, you know what? That's why. I'm not just jumping on bandwagons to be jumping on bandwagons. If someone thinks they want my assistance or want my help or want me to support a cause, they know where to find me. They can ask. Nobody's asked me to support one side or the other, and I'm not, because it's not my place to support one side or the other, because it doesn't affect me and I haven't been asked to. So there we go. we got a lot to cover. This is a long motion, and it's very eye-opening. We've had the first and the second sworn motions. I didn't read those. I didn't read those here on the air, but we have the third motion here. That may as well start with the final one, because everything has been building up to this. The first motion was shot down. The second motion that was made was shot down. And the third motion is sort of what has brought everything to a standstill. And that sun is coming in really bright through there. Let me pause for just one quick second and smash the curtains shut. Hang on. There. Now the lighting's a little more balanced. Okay, we've got 15 minutes to get through this, because everything can happen in 15 minutes according to the judge. Just kidding. Right. We don't have a like and subscribe poll set up today because I didn't have time. I was too busy preparing that awesome intro that nobody paid attention to. All right. Let me see. Where is the screen to bring up? We're going to hit the ground running today. And by hit the ground running, I mean 13 minutes after we start, 7 of which was an introduction. Okay. I've decided that if I do musical openings, and Tug inspired me for that. Tug inspired me to do the musical openings. But if I do them, I'm not going to do the 2 minute and 31 seconds or whatever it is, the grounds. We'll do one or the other. We won't subject you to like 5 minutes of opening stuff. This isn't Flashcast where they have like 17-minute introductions. 15 minutes equals 4 days for this judge. Absolutely. That's part of the problem. And that's, like I've said, it literally could have been finished in 15 minutes, I believe. I believe it could have been finished because she didn't swear to the things she was supposed to swear to. And that's literally all the cross-examination had to be. This is a document that's required to be sworn before it's submitted. Did you swear to this? No. Okay, judge, you have to dismiss this because it doesn't meet the legal requirements for a document to be filed. If she wants to make a new one and re-sign that and resubmit it, that's a different story. But this is all it should have been. And then the judge would have to go, all right, fine. He wouldn't need to call other witnesses. He wouldn't need to do anything because it is fundamentally flawed as a document, I think. But here we are, months later, and they've had to file this. This third petition was filed when? It was filed on September. January, September. It was filed on February 21st, 2024. Yeah, Urza, you're gonna have to rewind and listen to the lyrics to that intro because I think they were funny. Maybe we'll go over the thing at the end. Why did I trim my beard? Because you have to trim it every month or so. It's still got the it's just short on the side. It's just the lighting. The sides are still there. They're just small. You need to give the stash some volume, trim down the beard. And yeah, that's why. But it does kind of make the cheeks look puffier, but they're not. That's weird. It's just, last night. All right, we don't care about my face, do we? I don't. All right, let's go. It's a weird day today. Respondent's third. I like how third is italicized. That's clearly just them making a point. Look, this is number 3, judge. This is number 3 we're dealing with. For the third time, respondent Jeremy B. Hales moves to disqualify Circuit Court Judge Craig DeThomasis for a bias pursuant to Section 38.10 of Florida Statute Rule 2.330 of the Florida Rules of General Practice and Judicial Administration, and other authorities cited herein, and as grounds therefore states as follows. These are the general standards and principles that a sitting judge must meet when handling a case. That's what he's going to outline here. And which lawyer did this? Which lawyer wrote this? Let's scroll down here and see which one. Okay, this was Shockett. This was a Shockett motion, apparently. Yep, by Randall Shockett. It's a Shockett motion. I won't read all the Florida rules of general practice and judicial administration stuff, but anyway, Rule D1, 2330D1, requires a circuit judge to disqualify himself if a party fears that he or she will not receive a fair trial or hearing because of specifically described prejudice or bias of the judge. Now, this is interesting because the standard is the party themselves. It's a subjective standard, it looks like to me, where if a party fears something, then you're required to recuse yourself. It's not an objective standard. And he can specifically describe specific instances of prejudice or bias. And that's why he personally himself fears that he won't get a fair trial, which should require in and of itself the judge to recuse himself. F provides that only the legal sufficiency of the motion shall be determined by the judge against whom the motion to disqualify is directed. If it is legally sufficient on its face, the judge must recuse himself. So the motion they're talking about isn't the motion for the protective order or anything like that. It's the motion to recuse the judge. The judge has to look at it and go, okay, is this document legally sufficient? Does it meet all the requirements to be filed and submitted? If the answer is yes, the judge must recuse himself. Already, I have no idea how this judge is still sitting on this case with those two standards. I'm afraid that I'm not going to get a fair trial from you because you've done this, you've done that, you've behaved in this way, and I think that prejudices you against me, and here is my legally sufficient document. The judge should be required to go, okay, out of my hands. But judges don't like to be told not to do things. They don't like to be told that they can't hear a case anymore, especially if they like or don't like one of the parties, which they shouldn't be doing in the first place. So, that leads to them going, well, I'm not going to recuse myself, despite them having the possibility, or at least what it looks like on the face of it, the obligation to leave the case. Jed Hanswitz says, look again who wrote the motion. Okay. Certificate of service. Verification from respondent and co-counsel, see attached. Okay. This is the true and correct copy submitted by him. Why are we looking at who wrote it? I'm confused. Anyway, I was expecting there to be something there. Shockett wrote this on behalf of the other counsels. Not sure what that was all about, but okay. Ged, any clues to why I was supposed to do that? I'm just not sure. All right. Well, when determining the legal sufficiency of a motion, again, this was if it looks legally sufficient on its face, the judge must. There's no option. The judge must recuse himself. So, what does legally sufficient mean? A judge pursuant to section, the allegations must be taken as true. So that's what it means. When you determine whether or not this is legally sufficient, you have to look at everything that Jeremy Hales and his counsel put in the motion. The judge must take it as true. He must take each of these allegations that's coming up as true and accept it. And he's clearly not done that, and I don't understand why. And I hope the high court crushes him on this. The standards for disqualification do not turn on a demonstration of actual bias. So it doesn't have to be actual bias. It's just if the person themselves perceives there to be the bias. I'm going to try to embiggen myself a little bit here. Nah, that's not going to work, is it? I just tried to give you a bigger view of my already big, handsome face. The standards for disqualification do not turn on a demonstration of actual bias or partiality on the part of the judge or the judge's own perception of his or her own. Yeah, the judge is always going to say, I'm impartial. I'm not partial to any party. I'm a judge. We don't do that. Rather, disqualification is required where the facts alleged and established, which must be taken as true, would place a reasonably prudent person in fear of not receiving a fair and impartial proceeding. We have seen demonstrated over and over and over again this judge saying and doing things that would put any reasonable person in fear of not receiving a fair trial. I don't know how someone could be in front of the judge in this case and believe that this would happen. I'll get saying that the female lawyer wrote it. Well, she was typing furiously there at the table, getting it ready. I'm sure they all contributed, but he is the attorney that submitted it, I should say. It was written. I'm sure he reviewed it, being the lead counsel. He would have reviewed it, and then he signs that he and Hales have reviewed it. It's accurate, and then he submitted it. I see what you meant there. Okay, thanks, Ged. So rather, disqualification is required where the alleged facts are established, which must be taken as true, would place a reasonably prudent person in fear of not receiving a fair and impartial proceeding. It is irrelevant whether the judge agrees with the facts on which the fear is based. The judge doesn't have to agree with it. The judge doesn't. It's just the person's feelings. It is the reasonableness of the party's belief, not the court's perception of its ability to act fairly, that matters. Again, that's what we said at the beginning. It's the party's belief. It's the person's own individual belief. It's subjective to the party themselves. And if they say, I don't think I can get a fair trial, you have to take that assertion as true and then look at it to see whether they're just nuts or whether a reasonable person in their position, a different reasonable person, would have the same thought about not being able to get a fair and impartial hearing. And if you say, okay, a reasonable person would believe that, you've got to recuse yourself. But again, it gets down to the judges don't like to be told they're biased, and they can fight it, which is what this judge did. He dismissed, he rejected this motion. He denied it. And that's why they said, we're taking this to the higher court. So it's irrelevant. It's the reasonableness of the party's belief, not the court's perception of its ability to act fairly, that matters. The proper consideration is not whether a lawyer would question a judge's impartiality, but whether an ordinary litigant, an ordinary party, would reasonably question a judge's impartiality. Because a lawyer may go, all right, I know the judge, he is fair and impartial. He's just, he's having a mood swing today. It's the litigant, it's the party themselves, it's their perceptions that are at the core of this motion. The cumulative effect of events occurring within a short space of time can cause a party to have a well-founded fear that he will not receive fair and impartial handling of his case. It's not an isolated incident that warranted disqualification in this case. So again, this is an important thing. It's not one thing that the judge said that requires him to recuse himself. It's the amalgamation. It's this big conglomerate of things. It's the totality of all of these events, the little things. It's the straw that broke the camel's back. It's that scenario where one straw isn't going to break the camel's back, two isn't, but eventually you're going to put that one straw on there that's going to break the camel's back. And that's what he's saying. There's been a lot of straws piled up, and now one of them is finally one of them has broken the camel's back. Rather, it's a combination of two events that led to us to conclude that the trial court erred in denying the motion for disqualification. All right, well, we're going to find out what those things are. What are those two events, and why should they have required the judge to recuse himself? That's going to be the next part of this motion. And in the meantime, I just want to say we've been here 25 minutes, and I didn't put up a like and subscribe poll. So I'm just going to have to remind you a few times to get down there and smash that like button. I would deeply appreciate that. Let's get the numbers up there. Let's get the algorithm out. And if you haven't subscribed, please do. If you have, just double check to make sure you are. That's all I got to say. We have reached over the 74,600 subscriber mark. We're less than 400 subscribers away from 75,000. That would be awesome. I'm thinking of doing a 24-hour stream. I know I keep saying that every time we get to a significant number, but I'm thinking a 24-hour stream would be fun. maybe in May, maybe in the first week of May, because it's a holiday here. The May 5th is a holiday. So, we might do a 24-hour stream then. Just saying, if we get up to 75,000, which I'm sure we will. All right. And again, no fighting today. This has nothing to do with any drama that's going on between any two people on YouTube, because there's always plenty of drama out there in the tubes if we want to latch onto, but that's not what we're about here. We think people are adults, people are big people. They can solve their own problems. They can resolve issues between themselves. And nobody asked my opinion. Nobody involved asked my opinion or asked me to do anything. So guess what? Keeping my nose out of it. Someone that's involved asks me to do something, then I'll have to make some decisions and I'll have to decide what to do. So yeah, we're keeping all the stuff that you're wondering about. Oh, is he going to talk about this? No, I'm not, because doesn't deal with me. Me sticking my nose in only makes it worse. All right, basis of this third motion. Sorry, I just wiped my nose on camera. I've never done that before. Merch. Oh, and by the way, I make nothing off the merch. It's just fun stuff that we make to do this. Just so you can do it. And Urza, she designed this. No, she designed the Give It a Whirl glass. I need to get myself a Give It a Whirl glass. Sorry, I got distracted. I got distracted. Big surprise. Oh, hell. Wait, it's May already? No, it's not May already. We've got a month and a half before we get to May. Well, a month. We have like however many days are in April. Then it'll be May. Basis of this third motion. Let's see. I'll tell you also why I don't like drama, because you all just get all drama. You're not paying attention to me, and you're not sending the super chat. Just kidding. No. All right, shut up, Jeff. Let's go. I love all of you. You're all great. See, we can disagree with each other and be, amongst yourselves. I don't disagree with anybody. The motion is based from the respondent's point of view. Again, italicized. That's the emphasis. We've mentioned it ourselves. We've emphasized it a few times. It is the respondent. It is the person. It is Jeremy Hales' point of view. That's what we're looking at here. From the respondent's point of view, on the order entered February 14th, 2024 by the Honorable Craig DeThomasis, styled as Order on Respondent's Second Sworn Motion to Disqualify. Hereinafter, order. A copy being attached here to is Exhibit 1. In the order, Judge DeThomasis has denied Hales' second disqualification motion. A copy being attached here to, consisting of five-page single-spaced pages, which took issue with the merits of the motion, refuted the allegations contained therein, and commented inter alia on the validity of certain allegations. Should we look at Exhibit 1? Let's scroll on down here to Exhibit 1. Do we have Exhibit 1? Oh yeah, this is where are we at? Did we not put Exhibit 1 in here? Here's Exhibit 1. No, never mind. We don't have the judge's Exhibit 1. Nope. All right. We won't look at it directly then, because we don't have it. But he's going to tell us what's in it anyway. So, all right. Well, we're way out of the grouse there. Where are we at? Oh my! I need to start reading faster. Here we go. All right. So he's complaining and he's commenting here that the order the judge issued. Oh, I see what it is. All right, never mind. The judge issued an order, and the order should just be a very short thing. But he said it was 5 pages, single spaced, and not only did he talk about whether this decision, the only decision is, would a reasonable person, based on what's alleged in this document, cause a reasonable person such as the party to believe they can't get a fair trial. That's all he has to mention. But so he's complaining that the judge, he took issue with the merits of the motion, with the facts of the motion, which, as we read above, he's specifically prohibited from doing. They can't look and make any judgments based on the merits of the motion, based on the arguments inside the motion. Just, was the motion proper? That kind of a thing. Refuted the allegations. So yeah, the judge is refuting the allegations. He's defending himself in his order, which he shouldn't do, and commented on the validity of certain allegations. He's making rules. He's making determinations, or at least commenting on possible outcomes of certain allegations in the motion, which you shouldn't do. In accordance with controlling legal authority in the state of Florida in the district, a 2,549-word order has now become an independent basis for disqualification of Judge DeThomasis, and immediate entry of an order of disqualification is required. His order was 2,549 words long. The taking care of Maya case, the judge's order dismissing everything, reducing award amounts, I don't even think that was 2,549 words. Holy crap. A respondent learned of the order the day after it was issued. This is when all the facts constituting the grounds for this third motion were discovered by him and caused him to fear that he would not receive a fair and impartial trial. So, yeah, once we read this motion, we knew that the fair trial was out the window. Okay, they were trying to decide if they wanted to choose the word show or choose the word display, and they didn't delete one of them. I like display, as they display a deep-seated favoritism toward petitioner and antagonism toward respondent and respondent's counsel. That makes a fair judge impossible. We have a footnote. What's a long footnote? The Code of Judicial Conduct sets forth basic principles of how judges should conduct themselves in carrying out their judicial duties. Canon 3C1 states that a judge should disqualify himself in a proceeding in which his impartiality might be reasonably be questioned. This is totally consistent with the case law of this court, which holds that a party seeking to disqualify a judge need only show a well-grounded fear. That's all you have to show, a well-grounded fear that he will not receive a fair trial at the hands of the judge. It is not a question of how the judge feels. It is a question of what feeling resides in the affiant, in the complainant's mind, and the basis for such feeling. So yeah, again, it's not whether the judge got his fees hurt or how he feels and what he thinks about the merits of the case. It's a question of what does the person making the motion feel and what is the basis of those feelings. Apart from the order's volume and word density, I like word density. That's good. Apart from the order's volume and word density, the order provides numerous other grounds set forth herein, including those belied by the second, which warrant disqualification of Judge DeThomasis. Let's call him Judge D. We'll call him Judge DT. Maybe you got the DTs. I don't know. For the reasons set forth herein, Judge DT's excessive, self-indulgent order. Oh, there's a shock. There's a shock. Who would have thought that this judge would issue a lengthy and self-indulgent order? Oh, there we go. Surprise. This judge is self-indulgent and likes to hear himself talk. Dina, what's up, Dina? Dina with the dollars today. We got dollars from Dina. Thank you so much. Grateful for you in Chile and Seoul. It is nice and beautiful and warm here in Busan. It's what time? It's 10:38 in the morning. It is it's 11 degrees, 12 Celsius. It's 18 degrees Celsius. What's that in Fahrenheit? I've forgotten Fahrenheit. Convert 18 degrees Celsius to Fahrenheit. It's 65 degrees. Oh, that's why it's perfect. It's beautiful sunny weather. And as soon as I wrap this up, I'm going to go out and enjoy some sun, take the pig dogs for a walk on the beach, and we'll enjoy. Dina, I'm sorry to hear it's chilly in Seoul. It's 65 degrees. It's 11 degrees here in Busan. And Vince Clortho gifted one Legal Vices membership. If you were that lucky person that got the Vince Clortho gifted membership, make sure you give Vince Clortho, the Keymaster, a super special thanks. Dina, get some warmth up there. You deserve it. It's a beautiful day. You shouldn't be chilly. Purdue won. Okay. I forgot. It's March Madness. I forgot. I didn't pay a second's attention to basketball. Island for the $5. I appreciate that you're reading this, and it's Friday night of a long week here. Vice Squad dance break. There's going to be no dance break. Not for me. You can get Megan to do squats. Megan can do squats, but I'm just going to sit here and drink my coffee, talk to you, read this, and just be fat. Because that's what I do best. I be fat. Let's get back into this, peeps. Thank you so much for all of you there, for Vince, for Island, and and Dina. Sorry, skip my brain there for a second. Apart from this order's volume and word density, I just love that. For the reasons set forth herein, Judge DT's excessive self-indulgent order entered in contravention of the prescriptions contained in Rule 2 330 has exacerbated. I use the word exacerbated a lot in my letters. I've always liked the word exacerbate. Sounds much better than to make it worse. I like excessive exacerbation is, it can be a problem, but exacerbation in the right measure can be. Moving right along. All right. For the reasons set forth here in Judge DT's excessive self-indulgent order entered in contravention of the prescriptions contained in Rule 23, and it has exacerbated Respondent Hales' well-founded fear that he will absolutely not receive a fair trial before Judge DeThomasis, and a successor judge must be assigned to my case. Interesting the use of the word my there, but probably should have been his. Although this is Hales' third disqualification motion, the prior two were denied, and no judge has been disqualified in this case. So yeah, they have to make for number 3 here. Judge DeThomas's refutation of the merits of the motion is an independent basis for disqualification. When a trial court looks beyond the legal, remember that's the review. Keep that in mind. That's the standard of review. The legal sufficiency of a motion. Is this sufficient for filing? Is it sufficient to show that a reasonable person, such as the respondent in this case, would have a reasonable belief that they're not going to get a fair trial? That's it. That's where it ends. But when a trial looks beyond that, beyond the legal sufficiency of a motion for disqualification, and attempts to refute the allegations, gets defensive, gets butthurt, and tries to explain away his behavior, it exceeds the proper scope of inquiry, and disqualification is required on that basis alone, regardless of the correctness of the denial of the motion as legally insufficient. Bundy v. Red, there's a bunch of cases that support them, and I concur with that opinion there. Most recently in Manuel v. Estate of Manuel, lots of Manuels involved. When a judge has looked beyond the mere legal sufficiency. So what's the problem with looking beyond the mere sufficiency? When the judge looks beyond the mere legal sufficiency of a suggestion of prejudice and attempted to refute the charges of partiality, he has then exceeded the proper scope of his inquiry, and on that basis alone. This is not, mind you, this is not an argument. This is a court case. This is a judgment that's already come down from the 4th District Court of Appeals, which says right there. If you do this, if you attempt to refute the charges of partiality, if you get all defensive and butthurt and start defending yourself in a motion, you have exceeded the proper scope of your inquiry, and on that basis alone, establish grounds for the judge's disqualification. Our disqualification rule, which limits the trial judge to a bare determination of legal sufficiency, was expressly designed to prevent what occurred in this case, the creation of an intolerable adversarial atmosphere between the trial judge and the litigant. If that does not describe this case, if that doesn't describe what's going on in this case, I don't know what does. An intolerable adversarial atmosphere between the trial judge and the litigant. This judge has created an intolerable adversarial atmosphere between me and the judge, and I've got nothing to do with this case. So it's right there. It's bold. It's in another court case. It's from the 4th District Court of Appeals. It says right there. In this case, Judge DT's 5-page single-spaced order denying Hales' second motion to disqualify far exceeded the scope of proper inquiry and is in direct contravention of Rule 233H, which states, if any motion is legally insufficient, an order denying the motion shall immediately be entered. Oh, this is interesting. No other reason for denial shall be stated, and an order of denial shall not take issue with the motion. So the second motion, which the judge ruled was legally insufficient, the only thing his motion should have said was, this motion is denied on the grounds that is legally insufficient. Not 5 pages, single-spaced type, defending himself, commenting on the validity of the arguments, the accuracy of the arguments, whether it just says right there, if the motion is legally sufficient. An order denying the motion shall immediately be entered. No other reason shall be stated. He's not allowed to do what he did in his motion. I will lose my internet shit if he is not tossed off the case by the higher courts. I will absolutely lose my shit because this is so crystal clear. The allegations in Hale's second disqualification motion, which resulted in his well-founded, objectively reasonable fear of not receiving a fair trial by Judge DT, were based on the judge's prejudicial conduct and gratuitous derogatory comments directed to both Hales and his counsel at the hearing on January 23rd, 2024, and were indeed legally sufficient. Nonetheless, instead of entering a 4-word, again, surprise, Judge DT's denial should have been 4 words long. It was what, 2,500? Yeah, 2,549. Instead of entering a 4-word order stating denied as legally insufficient, in conformity with the rule, Judge DeThomasis crafted a 2,549-word order in which he took the opportunity to attack all 3 of Hale's attorneys, as discussed infra. The context of those comments in this record demonstrate confirmation bias, which is the well-documented tendency once one has made up one's mind to search harder for evidence that confirms rather than contradicts one's initial judgment. Despite the judge's bare contention that he was not passing judgment on the truth of the facts alleged, he did so. For example, Judge DT took issue with Hale's very assertion that as a result of what occurred during the course of a non-evidentiary hearing on January 23rd, 2024, Hales had a well-founded, objectively reasonable fear of not receiving a fair trial before Judge DeThomasis. Paragraph 9 of his order, however, directly disputes Hale's fear. Again, he's not supposed to be refuting anything. This is the judge stating, any objective review of the proceedings held on 1/23/24 would not cause a reasonably prudent person to fear not receiving a fair trial. The remainder of the paragraph then attempts to justify the court's conduct towards Hale's attorneys with vague accusations of, quote, their unacceptable behavior, contrary to law. See, that again is butthurt language. That's butthurt language. Their behavior was unacceptable and contrary to law because they contradicted me and they argued against me and they said things I didn't like. I don't see how the judge also doesn't get disciplined. If I was a party, I would have a very difficult time not filing some sort of complaint against the judge. I mean, it's beyond the pale. The fact that there's some rando lawyer dude on YouTube in Korea, shouting at computer screens in the middle of the night is ludicrous. But this is what the judge has driven people to. That's how bad he is. So the judge has criticized the Hales lawyers, their unacceptable behavior contrary to law, and which includes a pejorative reference to a collateral matter concerning Attorney Feather. Oh yes, the 15 minutes. I'm sure the 15 minutes was mentioned heavily in his order. Judge Feather that was dealt with by the chief judge and intended to be outside the purview of issues for consideration by Judge DT. Another obvious example of the court impermissibly challenging the allegations in a disqualification motion is found in paragraph 9A of the order, which directly addresses and refutes paragraphs 11 and 12 of Hale's second disqualification motion. That the averments contained herein are illogical, the assertions are illogical, irrelevant, and inconsequential. That's, as he says right here, that constituted impermissible commentary on the validity of the allegations in the motion. It further shows that the judge misconstrued the nature of an argument advanced in the alternative as being competing hypotheses. Yeah, he's not arguing against himself. He was presenting 2 possible situations as alternative. If you don't agree with A, then agree with B. Not A and B are true at the same time. As stated in Manuel and equally applicable here, the trial court's impermissible rebuttal of each allegation of the motion to disqualify was not cured by a threadbare qualifier that it was not passing on the truth of the statements contained in the motion. So yeah, you write 5 pages of your order talking about the truth and the accuracy of the assertions made in, made in the document, and then you put the one sentence, but this has nothing to, but this is not a whatever it was he said. This is not a comment on the truthfulness of the statements, but you just did it for 4 pages. Ugh. And Will Call Magic gave us the $2 super sticker. Thank you so much. What is that sticker? I can't see. I got to scroll down here a little bit. It is a fox or a Sheena Ibu going, woo, #1. That's us. Thank you so much, Will Call Magic. Appreciate you, brother. Thank you so much for the awesome support. Oof. Let's get into the meat. Hey, Flux. Flux just showed up. What's up, Flux? I didn't realize you were streaming. Yes, I am. I'm streaming right now. I think I need to hide. Flux is here. Everybody needs to hide. Flux is here. All right, people. Let's see what's going on here. We got Flux. Flux is in on our little club here. Additionally, in confronting the allegations of Hales' motion, Judge DT's order broadened the scope of consideration to previous court events and filings in what appears to be an attempt to validate his disparaging and accusatory comments directed towards Hales' attorney at the January 23rd hearing. The audio-video recording referenced by incorporation herein and is made available to the court by the 8th Judicial Circuit. These apparent root causes of the judge's bias against Hales' counsel permeate virtually every single paragraph of the order. Judge DeThomas's order does not consist of mere reports of perceived unprofessionalism, but instead summarily, repeatedly, and inappropriately condemns all 3 of Hales' attorney, including attorney Feather is not worthy of belief because of what the court perceives as a misrepresentation by Feather on 11/29 as to why Hales was unavailable on November 30th, 2023, to conclude his hearing that did not finish the day before. Yeah, so he's saying that in his order that Feather is not worthy of belief because he lied. He misrepresented when he said that Jeremy had to be in Ohio in court the next day. So he's not worthy of belief. That's what the judge is saying. And Attorney Feather's violations of certain administrative orders addressing video recordings of court proceedings promulgated by the Florida Supreme Court and the 8th Judicial Circuit justified DT's repeated and hostile open court accusations of misconduct, notwithstanding that Chief Judge Mosley was in charge of handling this matter. That was the contempt hearing. We'll look at the contempt hearing. That was a contempt hearing for releasing stuff, but had nothing to do with Judge DT, with Judge Grudge. Yeah, well, I forgot. We should just call him Judge Grudge. DT's like almost pronouncing his name. And so Attorney Inkles misrepresented to the court's judicial assistant the nature of her submission of a memorandum of law containing case law analysis as being nothing more than electronic copies of cases. At 4, Attorney Shockett conducted a video deposition of the petitioner without complying with Florida rules of civil procedure and in contravention of the applicable rule because he failed to include the actual name of the videographer in his notice of taking video deposition pursuant to subpoena ducis tecum. So yeah, that was the whole thing. We can't use that because you didn't do it properly because you didn't put the name of the videographer in the notice. As such, the court deemed itself justified in denying Shockett the ability to play portions of petitioner's video deposition to demonstrate that it was petitioner's erratic, dilatory, and evasive conduct which necessitated more time being required for Shockett to question her, which the court denied outright. So yeah, if you saw the deposition that LIEnette gave, we only saw 27 minutes of it, and it was an absolute shit show. I don't know what happened for 7 hours. But he said there was very little actual deposing going on during those 7 hours. And I can't wait until that's released. I will sit through every minute of that crazy, boring, weird, nutty 7-hour thing as soon as I possibly can. But this deposition did not go well because of her and her behavior. He said her erratic, dilatory, and evasive conduct. And so they asked for another deposition of her. But the judge wouldn't allow the Hales to show any of her erratic behavior because you didn't make that video properly. because you didn't mention the name of the videographer in the notice of taking the deposition. Can you imagine 7 hours of LIEnette? Oh, I can. I can imagine the grift on that. I want 7 hours of LIEnette. That'd be bad. And Vince Clortho, bringing down what everybody knows.
You are not a nice person.
She's not a nice person. Wait, hang on. My phone is vibrating heavily. Everybody's waking up in the world. All right. Sorry about that. Let me put it here where it's not gonna vibrate loudly. Where are we at here? All right. Thank you so much, Vince Clortho, for opening me up to using that little sound, that little video clip. So, as such, the court denied. And even though petitioner impermissibly used the Fifth Amendment to avoid answering questions related to her petition, accusations concerning abuse of discovery, however, are not a proper basis for a decision as to the rights of the parties. It's noteworthy that the majority opinion in Manuel v. Estate of Manuel Supra, it means above, was authored by Judge Sicklin, we'll call him Sicklin, who expressed the very same concerns in what had been a dissenting opinion just 2 years ago in M.D. Parker Associated v. Connor, where he said a trial judge should resist all temptation. A trial judge should resist all temptation to become indignant. Well, chalk up a big frickin' fail for Judge Grudge on that. That's all he knows how to do is become indignant. You should resist all temptation to become indignant and should promptly and succinctly rule on the motions in a few words or less. Communicate nothing further and move on. Well, that is genetically, this guy is programmed in such a way that is utterly impossible for him. In Manuel, the fourth District Court of Appeals fully acknowledged without exception the long-standing, well-established Florida Supreme Court rule that a trial court may not address the truth of the facts alleged in a motion to disqualify. The holding has always been the position of the First District Court of Appeal, whose authority is controlling in the 8th Judicial Circuit, Levy County, Florida. Judge Grudge's single-spaced order denying Hales' second disqualification motion was well beyond simply finding Hales' motion to be legally insufficient. It addressed and challenged the merits of the motion, exceeded the proper scope of inquiry for ruling on a motion to disqualify, and wholly disregarded Florida law regarding a trial court to view a motion to disqualify through the lens of the litigant, not on how the judge grades him or herself as the ability to act fairly and impartially. So that's the lens of the litigant is the lens with which we must consider whether or not the judge can act fairly and impartially. The order, with its repeated accusations of ethical misconduct on the part of Hales' attorney, exacerbates the intolerable adversary atmosphere between the trial judge and the litigant that the disqualification rule was designed to prevent. In conformity with the legal authority already cited herein, the 5-page single-spaced order denying Hales' second disqualification motion is an independent basis to disqualify Judge DeThomasis. The actual content, language, and tone of the order further provide additional basis to disqualify this judge as set forth below, and further establishes that Hales' fear of not receiving a fair trial before this judge is indeed well-founded. And I desperately need to cough. All right, we're back. Got a little dry throat there going on. How are we doing here on time? Oh, we're not even an hour into this. We still have a little more than an hour left together. Aren't you all excited about that? I am. Wow. I'm sort of starting to. I'm too chill today. I'm in like Zen mode. I just woke up. Had a lengthy Friday night, and I just woke up. I fell asleep on the sofa. So I rolled off the sofa, and once I could move my 54-year-old back again, I stretched out, came here, sat down, and started doing the show. So I'm in Zen mode. I haven't watched any video of the judge to make me upset, make me excited, but I'm sort of starting to feel like I'm missing something. I'm feeling far too much like Bob Ross with the happy little clouds of justice. There's no bad judges. There's just happy accident judges. I'm sort of, I'm sort of feeling Bob Rossi this morning. I'm not used to this feeling of, what would you call it, peace and quiet. All right. Let's see if any more of this gets me agitated. I'm missing my natural state of being agitated. Judge DeThomas's pejorative commentary on counsel's ethics, their unacceptable behaviors, and actions contrary to law, as well as what appear to be veiled threats to report all three attorneys to the Florida bar, requires his disqualification from the case. Why is any of this in a motion to deny, in his denial of a motion to recuse himself? What does any of this have to do with it? Bob Ross law racks, his good law racks. Yeah. Okay, JKD Buck. We're happy you're here today. We'll just color a little law over here. We'll just put a little bias over here in the corner. Oh, and let's make a happy little grudgy judge down here in the bottom corner. Just paint it. Let the canvas talk to you. Let Judge DeSantis into your heart and see the world through his eyes. And I don't know why I'm doing this, and I should probably stop right now. I have to kick my own ass if I'm not careful. To be sure, a judge who questions the veracity or ethics of a party or counsel may be subject to disqualification depending on the unique facts of the case. In his order, Judge Grudge states 4 different times that he admonished counsel at the hearing on 123-24 for certain perceived transgressions. What is this, like Adam and Eve? You've transgressed. You must leave the Garden of Eden. In his order, Judge Grudge states 4 different times that he admonished counsel at the hearing on 123-24 for certain perceived transgressions dating back to November 2023. Attorney Shockley was the only attorney who appeared with Hales in court on 123-24, yet he was not the attorney responsible for any of the perceived transgressions, and the court would have known that. Born sinner, you're funny. Yes, judge is stupid. The video record of the January 23rd portrays what those admonishments look like, including a resemblance to portions of paragraph 8 and 9 of Judge Grudge's order, to wit. Here's a trial transcript. It is the court's responsibility to assure counsel's adherence to the regulations of the... We need to give him a sinister voice. It is the court's responsibility to assure counsel's adherence to regulations of the bar as well as the code of professional conduct in their dealings with the court personnel, and opposing counsel. It is necessarily the obligation of the court to question counsel regarding behaviors affecting the administration of justice and to place on the record the specific critical concerns of the court, as was done in each of the prior hearings, and to allow response of counsel, if any, concerning any and all transgressions and or violations of law and or standards of conduct that directly affect the legal process of the case to be adjudicated by the court. Paragraph 9 of the order states in relevant part, to grant disqualification on the basis of the matters averred in the motion under review, which consists of confronting counsel with their unacceptable behavior and actions contrary to law, would be tantamount to allowing attorneys and or litigants to violate rules promulgated by the Florida Supreme Court, orders issued by the Chief Justice of the Florida Supreme Court, orders issued by the Chief Justice of the 8th Judicial Circuit, and to surrender and abandon all precepts of the regulated practice of law. And really big and really bold, if they are then called upon to account for such behaviors and or to answer or explain such behaviors and or are admonished for doing so, they should be allowed a fresh start with a successor judge. There we go. That's great. See, there you go. Enhanced font intentional. Yes, this gigantor, heavily bolded. That wasn't an accident. He intended to make it look like this. Judge Grudge's words are chilling, including for Hales, who is now necessarily concerned that each foray into Judge Grudge's courtroom will involve 15 minutes. You know that them putting in this 15 minutes of preliminary attorney inquisition, you know that choice of 15 minutes was absolutely deliberate. Should we make it 10? Should we make it 20? Nah, let's make it 15. So Hales is unnecessarily concerned that each foray into Judge Grudge's courtroom will involve 15 minutes of preliminary attorney inquisition on collateral matters, not to mention at his expense, which is what we've talked about from the beginning. The longer the judge talks, the more Jeremy gets billed before the merits of his case are addressed. Indeed, the record already reflects his intention to indulge in this exercise regarding a sequestration issue, which the judge appears to be applying in an overly broad fashion to Hales and his witnesses, who have not yet begun testifying nor were ever sworn. Specifically, Judge Grudge stated that when the parties return for trial on March 1st, the court will start with conducting inquiry as to who spoke to who, and will issue sanctions, including the exclusion of testimony. So here, the judge has already said that he's going to, rail the witnesses and demand to know who's been talking to who, and then sanction people. In light of the demonstrable history of this judge's disparate treatment of the parties, including selective interpretation and application of administrative and procedural rules as between the parties in this case, and his hostility and expressed condemnation of Hales' counsel, Hales' fear of not receiving a trial is both well-founded and reasonable. The doctrine of judicial independence does not afford judges the power to do as they please. Judge Grudge has professed justification in his order that it is the court's responsibility to assure the orderly administration of justice does not justify retaliatory conduct against the attorneys or the parties, nor does alleged misconduct or the good motives of a judge excuse departure from the guidelines established in the Code of Judicial Conduct. As the Florida Supreme Court stated in Erickson, above supra, Judge Erickson essentially believes that if a judge believes a defendant who exercised a legal right is attempting to interfere with the orderly administration of justice, that's exactly what's happening in this case. The judge believes that Jeremy, by exercising a legal right to question the judge's impartiality, Judge Grudge believes that is somehow interfering with the orderly administration of justice. That is spot on to this case. Judge Erickson essentially believes that if a judge believes a defendant who exercises a legal right is attempting to interfere with the orderly administration of justice, the judge has the right to react to the defendant by inflicting punishment upon him or her. However, even if a defendant knows that the exercise of a legal right may interfere with the orderly administration of justice, a judge cannot punish the defendant solely for exercising that legal right. That makes sense, doesn't it? Yes, doing action A may interfere with the orderly administration of justice, but if you have a legal right to do A, you have a legal right to do A, and you can't punish someone for exercising a legal right based solely on them exercising that legal right. There has to be more to it. To approve that approach would have a chilling effect on defendants who legitimately seek to exercise their legal rights and is contrary to the fundamental principles of due process. Emphasis added. All right, we got one star dinger. Tammy Fayette, another shot of coffee. Well, I think I will do that. Thank you very much. It is now room temperature coffee. Excuse me while I sniff here. I'm back. Thank you, Tammy Fayette, for that. I appreciate that. Tammy, welcome to Zen Law Racks Day. We're just being all Zen here today, and we appreciate you being here. Thank you so much. How are we doing over here, chat? I get frustrated when I have to do a lot of reading, and today is a purely reading and commenting day because I miss a lot of what's going on in chat, and I miss talking to you. Like when we're watching hearings and things while they're yapping, while Judge Grudge is doing his thing, I can be watching here in chat and highlighting things and bringing things up and addressing things. But when I do all the reading, I don't get to do that. And we've got 483 people here, and I'm so glad you're all here. And 363 likes. You guys are doing good. Even if I don't put up a like and subscribe poll, you're doing your job. Thank you so much. That's your job, to hit the like and subscribe. And if you have subscribed, please just double check to make sure you are. How are we doing? I mentioned that we were exactly at 74,600. How are we doing now? Let me check real time. What are we? Wow, 74,614. So many of you have already subscribed during the course of this show. That's great. Thank you so much. Continue to please, if you haven't subscribed, hit that subscribe button and enjoy Zen, relaxed, calm, cool, and collected law racks while you still can. Because We're probably not going to be this way, this way next. This is a good time for midstream. Monday, we're going to be doing our Maritime Monday, where we're going to be going over the latest developments in the Key Bridge collapse incident. I'll update people, and then we'll open up to like a question and answer, so you guys can ask questions about it, and I'll answer them to the best of my ability, or send you someplace where I think they can answer them better. So that'll be Monday, the Key Bridge collapse updates. Tuesday, we are likely going to read part 2 of Virgilio Aguilar Mendez's federal lawsuit against the St. Johns County and the law enforcement officers that pummeled him, kneed him, choked him, and tased him 6 times for essentially nothing, essentially an illegal stop. We'll do that on Tuesday. And then we'll see what's going on for the rest of the week. Thursday, we have our retro trial. So there we go. Well, that's just kind of a general thing of what's coming up. We've got exactly 500 people here now. Thank you guys. You guys are awesome. Thanks for joining. And, tell your friends about us. So, all right. Linda Evans. Happy Easter, Linda Carter. Happy Easter, Linda. Happy Easter, Linda Carter. Linda Carter. She played Wonder Woman, didn't she? Good. Anyway, Linda Evers. We got some Linda Carters. We got lots of Lindas here today. Oh no, all chill, cool. Does anyone else get the feeling the judge lives out of his office? Murphy Bednall. Yeah, he does kind of strike me as the judge that really likes being there and likes seeing himself on the bench. And I'm a judge. I'm a judge. Jeff took 15 minutes admonishing us for not voting in the non-existent poll, though. Oh, did I say that? I didn't do that. I would never do that. I admonished myself for not having time to put up a like and subscribe poll today. Have they found the missing people from the bridge accident? They found a couple. We'll talk about that on Monday. Little things like in that transcript, use Easter eggs. It's Easter. It's right. Yes, exactly. The 15 minutes. That was a little Easter egg on Easter. It'll be Easter soon here. Flux asks, did you hit the button? Have you subscribed yet? Those are the first questions that need to be answered. All right. We've got our second wind here. We've cleansed our palate from section 2 of this motion. Let's jump into section 3. And I just want to do a quick look here. We are on page 13. I think this is a long motion. Where's the end? Where do we get the end? Okay. If I shut up and talk a little bit faster, we'll get through this. You can do it. Okay. Here we go. Yes, Wonder Woman was Linda Carter. Yes. And we were just wishing. Linda Carter's here in chat. The live one. Is Wonder Woman Linda Carter? Is she dead? Anyway, all right. We're so inside my ADHD brain. All right. That's what goes on in my brain 24 hours a day. That was a joke. That was the joke. I see. Gotcha. Oh, she is alive. Don't feed my ADHD, people. I just said we don't have enough time to get through this. And then I'm saying all the things in my head out loud. And that gets us nowhere. Literally. Flux. Flux. Shame on you. Judge. Drama face. Judge DeThomas's hostility and animosity towards Hales' counsel is a basis for his disqualification. Okay, now we're going to see what he's been saying about Hales' counsel and why that's a basis for his disqualification. Ginger with a Soul likes morning voice, Jeff. Me too. You're the first people I talked to this morning. Ordinarily, by the end of the day, stress levels up to here, and I've had it, and my voice tends to tighten up, and I get a little bit agitated. But you get the morning voice. Jeff got red faced. Well, just anyway. Morning Jeff gives me confused feelings. No, focus, Jeff. Thank you. Thank you. Astral Nomad. I'm focusing on you. And Tammy Fayette likes it when I say your name. All right, shut up, Jeff. Well, I can't shut up. If I shut up, then we won't have a straight heart. Focus. Draw my face. References to the record are taken from the official redacted video. He's underlined redacted. I love it because that was the whole big thing. This video's not been redacted when there's really nothing to redact on the video. So again, as with the 15 minutes, a few paragraphs before, he's underlined this video has been redacted. I like that. Should have said it should have been like a 15-minute version of the video. He could have called it the 15-minute redacted video recording on the January 23rd, 2024 hearing. The bracketed timestamps next to the quoted excerpts of the proceedings are as close as possible to the time increment on the recording. Bias against Mark Feather. I need some voices on my sound. I need some voices on my soundboard. Paragraph 7A through C of the order addresses court hearings that occurred early on in the case on November 29th. Oh, God, I hate talking about the November 29th hearing and December 6th, 2023. Attorney Feather represented Hales at the November 29th proceeding. Attorney Shockett and Shockett Law Group. That would be a great name for like an 80s like Euro band. Yeah, the Shockett Law Group. Shockett Law, everybody Shockett Law, Shaka Khan. Everybody Shaka Khan. Entered the appearance shortly before the December 6th hearing. It's a bad day for me. What Judge DeThomasis apparently perceived as egregious misconduct during and surrounding these early hearings quickly became a running polemic that continues to this day. Doesn't it though? It's like he can't get off of this next day thing. He can't get off of this 15-minute thing. It's like a meme. It's becoming a meme in his own courtroom. Or as I love how LIEnette calls them memes. He made a meme of me. It took me like 5 times for her to figure out she meant meme. She keeps saying, he made a meme. I'm like, oh, what? So yeah, he's got this meme going now. It's just become a redundant meme. The 15 minutes and the November 30th appearance in Ohio. Hey, happy birthday, Maria. It's Maria Lima's birthday. Happy birthday. Cheers to you. You deserve an awesome day. I hope tomorrow, here's my cheers. Here's my toast for you. It's your birthday today. Tomorrow, may you wake up to a house full of hidden eggs and baskets full of candy and chocolate and fruit and other delicious edible things. I hope that I hope that toast comes true. Okay, Shaka Khan, let's get back into this. It's quickly becoming a running polemic that continues to this day, and it is being used to justify denials of due process to Hales. Maria Lehman says 11/29 is my birthday. What? Oh, that's my birthday. I thought you said it's my birthday. Okay, I take it back. But anyway, I like you, Maria Lima. So still, anyway, tomorrow may you wake up to a house full of eggs and chocolate and candy and all that other stuff. Everybody, I wish that on every one of you. Paragraph 7A references a statement made by Attorney Feather to the court at the end of the day on November 29th. God, we have to read more about this. Oh my God, I hate this. But this is him yelling at the judge for doing it, so we can read it. On November 29th, regarding the possibility of concluding the hearing that had not finished the next morning at 9 a.m., Mr. Feather's words were, "No, Your Honor, Mr. Hales is having to address matters in Ohio court related to this situation. He has to be there tomorrow morning." The court thus scheduled conclusion of the hearing for December 6th, 2023. From Feather's statement, the judge assumed that Hales had to be present at a court proceeding the next morning in Ohio court. Again, nowhere does it say that. It says he has to address matters in the Ohio court. He has to be there tomorrow morning. Rather than consider the possibility that Feather simply misspoke or failed to phrase his response more articulately, and that's the one that I say. I say he's just, he could have explained more clearly what happened. I can see the miscommunication. But the judge can't, obviously. The judge immediately reached the adverse conclusion that Feather intentionally displayed a lack of candor with his tribunal and obtained a longer continuance for his client based on misrepresentation. Ironically, On the electronic recording of the January 23rd hearing, the court speaking rapidly stated, this judge has spent 40 years almost a daily basis in a courtroom. Although that statement gives the impression that Judge DeThomasis has been serving as a judge on the bench for 40 years, we know this is not the case. Oh, see? Yeah, this judge has spent 40 years on an almost daily basis in a courtroom. Is the judge a liar because he said that he's been a judge for 40 years? No. We know this is not the case. Immediately assuming that the judge lied in making that statement when he merely did not articulate his words carefully would be absurd. Nonetheless, in this order, Judge Grudge continues to impugn Feather with this statement months later after having reached a negative conclusion without ever affording Feather an opportunity to be heard. Such conduct is the antithesis of impartiality. It is apparent that the court's bias against Feather manifested itself at that point early on when the judge assumed without more that Feathers lied to the court. It quickly intensified when the court also learned soon thereafter that Feather requested and obtained unredacted versions of video recordings of 1129 and 12-6 hearings, which he provided to Hales, who broadcast them in conjunction with his YouTube program, What the Hales. Once bias became manifest, confirmation bias followed. Florida Supreme Court Administrative Order, which was designed to further standardize court operations and minimize unnecessary workloads for the trial courts while continuing to protect from inappropriate release any confidential information that may be captured on electronic recordings when electronic recording equipment is used in the courtroom, and local administrative order of the 8th Judicial Circuit contains procedures for obtaining copies of electronically recorded court proceedings. Entitled Safeguarding Confidential Communications When Electronic Recording Equipment is Used in the Courtroom. It states that, pursuant to Florida Supreme Court Administrative Order, before any CD is released to a non-party in the case, it shall be redacted of any confidential material found therein. It also provides that unredacted copies of audio-video recordings when electronic recording equipment is used in the courtroom may be made available to attorneys of record, parties to a case, and self-represented litigants upon request, so long as an acknowledgement is provided with the copy that states that confidential information may be contained on the recording. Further dissemination of confidential information contained on the recording is prohibited, and violation of that prohibition against dissemination may subject the requester to an action for contempt of court. Redacted copies of audio-video recordings when electronic recording equipment is used in the courtroom are made available to the public at large upon request by the 8th Judicial Circuit. As attorney Feather signed the required acknowledgement when he requested the 2 unredacted recordings and unwittingly furnished them to Hales, who published them on his YouTube program, Feather received an order to show cause issued by Chief Judge Mosley on January 17th, requiring him to appear before the Chief Judge and show cause why he should not be held in contempt. That was the contempt hearing, which I said, we're going to watch that. We'll probably watch that next time we do a Hales thing. Could be Wednesday, it could be Friday of next week. We'll see. I want to watch that contempt hearing. So on January 17th, he was required to appear before Judge Mosley, who issued the show cause order to say, okay, here's my deal, and here's why I shouldn't be held in contempt. Why I should not be held in contempt for purportedly violating the Supreme Court and local administrative rules as to the unredacted recordings. Feather appeared with counsel before the Chief Judge on February 7th and received a sanction commensurate with the offense, the monetary portion of which was vacated sua sponte. So the judge found him in contempt for releasing this unredacted video and fined him a certain amount of money. And then the judge said, you're being fined this, but then later, I guess he thought, okay, that's too much. And so the judge, by his own authority, which is what sua sponte is, the judge on his own authority said, that monetary fine that I assessed, never mind, you don't have to pay. This administrative matter involving Feather was collateral to the instant court proceeding, which is true and should never have been brought up or mentioned by Judge Grudge in this case, but Judge Grudge made it a centerpiece. That the Chief Judge of the 8th Judicial Circuit took charge of Feather's matter and not Judge Grudge indicates that keeping the matter separate was intentional and important so as to avoid even the appearance of prejudice to Hales arising from his own attorney being sanctioned by the judge deciding the merits of Hales' case. Makes sense. Put this my brain has just gone blank. The sanctions. Put this matter before a different judge because we don't want the judge hearing the case to be responsible for issuing sanctions against the lawyer that's handling the matter for one of the judges. Put it before another judge so you avoid even the appearance of prejudice. That objective was not and could not be accomplished because, as shown by Judge Grudge, comments and demeanor in the video recording of January 23 proceedings, he could not keep his antipathy towards Feather from impacting his judgment on substantive issues in the Hales case. The confirmation bias extends to attorney Shockett. So now he hates Feather, so now he hates Shockett because, they're working together. In the order denying disqualification, Judge DeThomasis makes it appear that he was the trier of fact for Feather's contempt matter, made adverse findings against him, and admonished him accordingly when such was not the case at all. The judge may have lied. Jeff, stop reading chat. I'm not reading chat, but now I'm reading chat because you made me burning. I hate you. I hate you. I saw my name and I looked, and now it's all everyone can blame Burning for this weird little deal here. All right. So the Judge Grudge may be stretching the truth or giving the wrong impression, which is what he accused Feather of doing by making it look like he was the one that issued the sanctions. Because in paragraph C of the order denying the second motion to recuse himself, there was undisputed evidence that confirmed attorney for the respondent, Mark Feather, despite having previously signed an attestation that he was aware of the admonition regarding the prohibition against dissemination of unredacted copies of court proceedings, did disseminate an unredacted copy of the 11/29/23 court proceedings, as he was the only person to have requested an unredacted copy, and his client, the respondent, did then broadcast the unredacted copy on his social media platform. It was true as alleged in the motion under review that counsel was admonished on 1/23/24 for such behavior, as it was contrary to the dictates of the Florida Supreme Court and the Chief Justice of the 8th Judicial Circuit. Paragraph 7D goes on to state, it is true that on 1/23/24, the court did express dissatisfaction and admonished counsel and the respondent for broadcasting unredacted audio video recordings of court proceedings. Despite ... So yeah, the court did express dissatisfaction. When a judge says the court, he means his own courtroom. He should have said Judge Mosley admonished, but he said the court expressed dissatisfaction and admonished, implying that it was him that did this, which we know it wasn't. Interesting. The bolding in the paragraph was done by Judge DeSantis. This wasn't Jeremy making a point. This was Judge Grudge making a point by putting all the bold stuff up there. Interesting. The underlining was done by the writer for clarity. Paragraph 7B, R.E. Feather's perceived misrepresentations to the court. Let's get there, but first I have to do this. And I'm back. Nobody wanted to see me blow my nose. Paragraph 7B, R.E. Feather's perceived misrepresentations to the court, states during the proceedings held on 12/6/23, the court learned from co-counsel Randall Shockett that the respondent himself on the record that the respondent did not actually need to appear in Ohio on 11/30/23, and that he only needed to sign documents 2 days later with his attorney in Ohio. As a direct result, it is true, as alleged in the motion under review, that the court did admonish counsel for a lack of candor towards this tribunal, and such behavior was again addressed on 1/23/24, as the court considered the totality of circumstances in the case when deliberating an additional motion being adjudicated. Mark Feather, however, did not appear at the January 23rd hearing. He was admonished at a hearing he didn't even attend. Mark Feather, however, did not appear at the January 23rd hearing, nor any hearings after November 29th. As made clear by his own order, Judge Grudge admonished Shockett for purported transgressions that Shockett didn't commit, merely because he happened to be the attorney in the room on Hales' side of the case. And he was admonished on particular one issue by a judge who exceeded his authority in taking up a cause that was assigned by the chief judge to the chief judge. Despite Feather's physical absence at the January 23rd hearing, he was certainly present in spirit. I like that. I like that. Despite his physical absence, He was certainly present in spirit and clearly at the forefront of things considered by the judge. He wasn't there, but he was there in spirit and so far up Judge Grudge's ass that Judge Grudge could not get him out of his ass and mind. Because the judge said, from the first hearing on November 29th, when respondent was represented by Mark Feather, his misrepresentations to the court, which gained his client the first of many continuances, then a few seconds later, misrepresented why the continuance was necessary. The court relied on the misrepresentations. Then a few minutes later, nine seconds later, and then when the court asked for the following week, Mr. Feather, who represented no objection to that date, 7 seconds. There was no pushback. There was no judge. I might have something. And I point out that because I want it to be addressed by both counsel that on 11/29, respondent was represented by Mark Feather. When offered an opportunity to reconvene the hearing on the following morning at 9 a.m., made misrepresentations to the court, which gained his client the first of many continuances. He misrepresented why the circumstances was necessary. The court relied on the misrepresentation and granted the continuance. And then, when the court scheduled it for the following week and Mr. Feather represented no objection to the following week, a few minutes later, totality of circumstances, which I'll discuss at a relevant point here this morning, 1603, day 1 was continued and offered to be continued the following morning, 11/29 to 11:30. When the record reflects the respondent got a continuance from on 11/29, the first continuance based on misrepresentation to the court. Next, what really becomes just in short, day 1 was continued, and despite offering to reconvene the following morning, November 29th to November 30th. Next, let's talk about context. Your current co-counsel to this day, Mr. Feather, represented that he could complete the case in 15 minutes. Oh God, 15 minutes. Your co-counsel, in violation of the Supreme Court order and in violation of our Chief Judge's administrative order, despite that, obtained unredacted copies of the 11/29 and 12/6 proceedings and is now answering to contempt charges from the Chief Judge. God, look at this. I'm not going to read these. So these are all in one hearing, the times that he brought up Mark Feather, who was not in court at that time. Well, let's just count them. 1, 2, 3, 4, 5, 6, 7. This has 2, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18 times. The judge brought up Mark Feather or Mark Feather related incidences 18 times when he wasn't even in the court that day. Ugh. Grr. All right, I'm looking through chat here. What am I missing here in chat? What am I missing here, peeps? It says who cares if she watches? It benefits legal vices. Who's she? But of course she's watching, and she can't shut up. So logic. Who's watching me? I always feel like somebody's watching me. Who's watching me? I feel like I'm being watched. Dun dun dun. Anyway, so somebody's watching me. Nobody's telling me who's watching me. Oh, I was accused of being LIEnette. Island was accused of being LIEnette? That's funny. That's actually really funny. Unless it's you, because you got accused of being LIEnette. It's probably not funny to you. No, Island is not LIEnette. Linda Evans and John Forsyth. Whatever. Anyway, hey, LIEnette, if you're here, howdy. Good to see you. Perhaps you will see how poorly everything looks. All right, so let's continue. All right, I was just curious. Of course, I assume that somebody's watching. So, anyway, no biggie. I thought I was missing something. Right, having repeatedly castigated is a good word, having repeatedly castigated Feather in the litany of derogatory references to him in a manner disguised as totality of the circumstances, the judge directed that hostility towards Shockett. For example, in discussing the many challenges that Shockett faced when taking the deposition of Preston, who was pro se at the time, pro se without a lawyer, the judge launched into cross-examination of Shockett, as further evidenced by his tone, body language, raised voice, and inappropriately aggressive demeanor. So you're giving her advice. Do you agree that the depo was taken by video as opposed to just audio was proper or improper? Do you agree that it's been broadcast on your client's YouTube channel? You have to answer that. Did you tell me you've done anything? And has it been successful? Would you agree they've been unsuccessful until today? But that being said, in the context of this rule of safeguarding is the attorney's responsibility. But now you know it's being posted on YouTube. Hey, Tammy, what's up? Interesting. I'm watching you guys talk here in chat. This is the beauty of court proceedings in the United States. They're open proceedings, and anybody, fans of LIEnette, fans of the Hales, fans of Judge Grudge, fans of Legal Vices can all go to these open courts and sit down. Anybody can be in a court hearing. Anybody can be there because they're open and they're public. I love them here. Tammy Fayette, is it unnerving to be watched by 500 people? No. It might be for some, but not particularly for me. For those of you that don't know, way back in the day, I worked in radio for 5 years in northern Utah and at several stations in northern Utah. So I'm used to, 500,000 people listening to me at any given time. So yeah, I'm cool with it. But it can be unnerving to some people. But if it is unnerving to people, and if people are kind of weirded out, just think you're just talking to one person. You're just talking to the microphone. Or just think you're talking to your mom or your husband or your wife or your significant other or whatever. Just focus on talking to one person. You shouldn't get worried too much about it. Oh my God, there's 506 people watching me right now. Hi, 506 people. Make sure y'all 506 of you hit that like button and subscribe if you haven't done so, because that'd be awesome. Rename yet? No. No. Right, here we go. Oh, Jeff knows he has a pretty face. No, he doesn't. Judge Grudge's interrogation of Shockett was that of a zealous advocate. And we all of us lawyers and law adjacent people that followed this mentioned that he was becoming a zealous advocate. And that's why when I watched this first hearing, I couldn't figure out what all this stuff was that people were talking about. This crazy judge who's gone off the rails. This woman who's making weird allegations and assertions and things. And I was like, I'm watching this and I'm going, okay, this is a good judge. This judge is making right decisions. He's helping out someone who is not represented by a lawyer, which is not uncommon. You need to give people who don't have lawyers a little bit of extra leeway, not much. But then when we got into this 15-minute thing, when we got into this scheduling thing, the judge just lost his shit and went off the deep end, and he became, it says, a zealous advocate for LIEnette at that point. And I was like, oh, this makes sense now. And then he's never left that. It's the confirmation bias they're talking about in this section. Weird people. So, Judge Grudge's interrogation of Shockett was that of a zealous advocate. Given that the judge had not treated Attorney Shockett in such a manner in prior hearings, coupled with the fact that the judge has already recited Feather's perceived transgressions multiple times at that point, it would certainly appear that the judge's extreme bias against Feather had now transferred onto Shockett. Don't you hate that? When someone's pissed at someone else and you're affiliated with that someone else, so then they get pissed at you? A trial judge's conduct crosses the line of ostensible neutrality and impartiality when he becomes overly involved in a hearing. Department of Child and Families, VJJ. You can't have Department of Child and Families, VJJ. Oh God, it's almost noon and it's still too early to have Department of Child and Families VJJ. Oh God, I hate my brain sometimes. Excessive participation by a trial judge may amount to usurping the functions of counsel and be an abuse of. I'm so glad Megan Fox isn't here. This would get out of control very quickly. Excessive participation by the trial judge may amount to usurping the functions of counsel and be an abuse of the discretion and latitude of the courts in such respects. which resulted injury to the rights of a party or parties. With resultant injury to the rights of a party or parties. A trial judge's failure to remain neutral during a proceeding is also a due process violation that requires reversal. Judge Grudge's adversarial conduct towards attorney Shockett has created and exacerbated Hales' fear of not receiving a fair trial by this judge. Judge DeThomas's comments, including towards Shockett himself, were not a mere expression of dissatisfaction, but a running diatribe of antipathy harkened back to the first day Shockett appeared in this case on December 6th, 2023. Let's see what oh God, there's more judge ranting that we've already heard. And nonetheless, we have current counsel in a case who files a motion to continue 24 hours and 20 minutes before a case he knew he couldn't be prepared for. Files another motion to continue, which would have been about the third motion to continue, if not the second, depending on how you look at it. When the record evidence establishes that the court accommodated current respondent's counsel when he needed a continuance, and when he got into the case knowing the case was scheduled, and he said he couldn't be prepared, and he came in as co-counsel to a lawyer who told this court on November 29th, somewhere between 4:50 p.m. and 5 p.m., Judge, I only need about 15 more minutes to conclude the entirety of my case. I found that to be incredulous, to be an understatement of the morning. But he files something, again, another filing after hours. But instead, in relevant part as relates to today, Mr. Shockett, who is co-counsel to Mr. Feather, files a notice of appeal 24 hours and 20 minutes prior to commencement of the hearing that was scheduled to conclude these proceedings on 12/6. And so for counsel, this is concerning to the court, for counsel to describe the efforts of an attorney who steps in with a limited notice trying to address the issue of calendaring the event. Next case. It includes potential violation of oaths of attorneys or attorney, one who is answering to the chief for violation of the injunction, which implicates you, Mr. Shockett. And it's so hard to read these court transcripts because this judge, he's rambling. This is what it's like probably trying to read transcripts of like Donald Trump or someone like that who just talks, just says shit. And doesn't really try to put them together in a coherent sort of sentence. I did have a chance when Trump was here in Korea, 2 years ago, 3 years ago? 3 years ago, I think is when he came to Korea. I had a chance to talk to his interpreter, his real-time interpreter. And he said, yeah, it's just impossible because they don't speak in complete sentences. He stops in the middle of one sentence and starts another sentence. He just reads he just says parts of a sentence, then he'll skip to a different idea, and it's hard to put together into a coherent thought. And that's exactly what the judge does here. He's just spewing. He's just giving this Faulknerian stream of consciousness lecture on law. And it doesn't work. And I can't read this, so I'm going to skip it. Because I don't know where to put the pauses and breaks because he's just all over the damn map. The fact that the judge repeatedly reminded Shockett that he was Feather's co-counsel strongly suggests the judge's antipathy, and indeed his bias has extended to Shockett. As shown by the video in this record, Judge Grudge's hostility towards counsel was not just evident in his words, but in his indignant and sometimes sarcastic tone and voice inflections, his body language, and even his finger pointing either at Shockett or audibly down onto his papers to punctuate what he was saying. Yes, he did the desk pounding quite a bit to punctuate what he was saying. A judge should disqualify himself or herself in instances where the judge has a personal bias or prejudice concerning a party or a party's lawyer. Says this case, where alleged characterizations of Murphy's counsel as engaging in ploys and having a history of filing late motions and blaming court staff by itself could have rendered Murphy's fear of bias a reasonable one. Now he's attacked. See how we got about 10 pages left, I think. And how are we doing on time? 20 pages, 10 pages in 20 minutes. Let's see. We're on page 23. Boom. 23. And this goes down to page 34. Yep, we have 11 pages and about 20 minutes. We can do this. We can do it. Especially if we skip all this nonsense here. So, all right. Anything cool going on over here in chat? Hi. All right. Nothing is jumping off the page at me. You're all having a great conversation with yourself. No lawyer in America could have been prepared. LIEnette accused Feather of a bribe and filed it Wednesday night. Jeremy hired Chocolate on Thursday, and the court was Friday. Exactly. But the judge didn't want to listen to any of that reasonableness because, he's an idiot. He's a biased person that needs to be thrown off this case. Judge Grudge's attack on the memorandum of law drafted by attorney Inkles. Is Inkles, is that how we pronounce her name? Omitted and ignored material facts to justify his condemnation of counsel. Although Hale's second motion for disqualification made no mention of the memorandum of law in support of respondent's motion for sanctions, including involuntary dismissal, which was presented to the court by Shockett but drafted by Inkles, whose name appeared on it, Judge DeThomasis has addressed the memorandum in paragraph 7 of his order. It's true that in the motion, okay, this is his order, so it's probably going to be a little more coherent. Yay. It is true, as alleged in the motion under review, that on 123-24, the court also commented upon a proffered memorandum of law that was presented to the court by attorney Randall Shockett, submitted on 122-24. See the docket entry 1997. Hang on. I just got a work text coming in here. What is it? What the hell? All right. Sorry about that. Had a work text come in. I'm not sure what that means, but hey, I'm here with you guys. They can wait 30 minutes or whatever. All right. It's true. Damn it. I've lost I apologize for that break. Okay, all right. That in the court's view, unnecessarily, unprofessionally, and gratuitously criticized opposing counsel for filing a limited notice of appearance for the purpose of advancing argument to continue on behalf of the petitioner's counsel averred he had a conflict and could not and would not be able to serve as counsel in the event that the court did not change the next scheduled hearing date from 1/26, date previously scheduled. As the record would indicate, the court did admonish respondent's counsel for presenting such an argument and in such a manner, as the court also remarked and reminded Mr. Shockett that he, Mr. Shockett, filed his own notice of appearance 24 hours prior to an already scheduled hearing date, scheduled for 12/6/2023, and as a result, he advanced argument that he could not possibly be prepared and thus required a continuance, which was granted. The rhetorical and condescending language advanced in a filing labeled as a memorandum of law and which described as wholly unacceptable behavior of opposing counsel was in fact the same behavior previously exhibited by respondent's counsel. It was not the same behavior. And again, this has nothing to do with the order. This should not have been in the order. This judge sucks. I'm getting agitated. That's cool. The memorandum consisted of 11 pages, with the first 8 pages devoted to Preston's discovery misconduct. The last 3 pages addressed the conduct of Preston's newly retained attorney before he even entered an appearance of record because he stopped properly noticed and scheduled depositions, including for a third-party witness he never intended to represent, from going forward when trial was scheduled a week away. Failing to mention anything about either Preston's discovery misconduct or that of the attorney in obstructing discovery, and without having even appeared in the case, let alone filed a motion for protective order, wholly ignoring the predominant argument regarding the obstruction of discovery, Judge DeThomasis created the appearance that Hale's counsel was upset merely because a continuance was requested by Preston's lawyer once he finally filed a limited appearance in this case. The judge's omission of these material facts when making derogatory comments about the memorandum not only revealed his strong antipathy towards Hale's counsel, but also his partiality toward Preston's new lawyer, who regularly appears before him. And although the order calmly states that he admonished the attorney for such filings, the audio-video record more accurately reflects a scathing and degrading attack. Upon reading the transmittal email to his judicial assistant, which attached the memorandum, the judge stated, attaches the case law portion. Let's see, part of the characterization in his argument, which at one time was called case law, was really not case law and is styled as a memorandum, including extreme argument, quite frankly, that describes in part the limited appearance of an attorney on behalf of the petitioner, but accurately today here on behalf of arguer continuance, quote, memorandum of law, unquote, for counsel to describe the efforts of an attorney who steps in with limited notice, trying to address the issue of calendaring the events. We have the attorney calling that bad faith, and skipping all that nonsense. I cannot read his ramblings. I'm sorry, I just can't do it. In addition to remarking that the memorandum was filed late last night when it was filed at 6:55 p.m. and the memorandum engaged in name-calling when it characterized improper conduct only, Judge Grudge entirely neglected to mention that the factual portion of the memorandum detailed the actual misconduct was filed 2 days prior on Friday at 5:22 p.m., which the judge also criticized because his oral directive that was never reduced to writing was stated to be 5 p.m. Although Preston's new attorney filed the document at 8:12 p.m. So he's like, yeah, we filed this days before at 5:22 p.m. and we get yelled at, but her attorney files it at 8:12 p.m. right before, and this is what happens. They don't get yelled at. It's always us. Yet despite Preston's attorney having filed his motion for continuance over 3 hours late, the judge heard that motion without comment. However, when Shockett mentioned that the issue complained of was the attorney's conduct before he was even in the case, Judge DeThomasis cut him off, saying, "You're arguing the merits of your motion." Also neglected to be mentioned was that in the top of page 13 of Inkle's factual portion, styled as motion, it says case law analysis, not just case law, followed by a few short paragraphs of introduction and the following language at the bottom of the page. Due to the 5 p.m. deadline, counsel did not have time to complete the case law analysis portion, although the research is essentially done, but another few hours is needed. A supplemental motion with the case law pertaining to assignment of sanctions against a party versus against a lawyer will be filed prior to hearing. So then, yes, we've just given you the case law. We're getting finish our analysis and we'll submit that before the hearing. Sounds perfectly reasonable, perfectly natural. The totality of circumstances and cumulative effect of derogatory remarks from the judge disparaging, criticizing, and finding fault with anything and everything said and done by Hales' attorney caused Hales to have a well-founded fear of not receiving a fair trial before this judge. Given Judge Grudge's litany of harsh words directed at Hales' counsel and distortion of facts used to further condemn Hales' counsel, Hales' fear is indeed reasonable. That's the fear that he's not going to be able to get an impartial and fair hearing. Well, Judge Grudge's employment of double standard in his interpretation and application of rules favoring Preston and prejudicing Hales requires disqualification. Okay, we're going to be talking about the double standard. That's good. That needs to be addressed because that is the one thing that's really irked me through this entire thing. Irked is a good word too. It's annoyed me and irked me from the beginning that if Hales' side comes even close to doing something, the judge goes apeshit. But if LIEnette's side does anything they want, they get to do it without any condemnation or even questioning or requirements of proof from the judge. And before we move on, let's Island here. Island says, started watching you a year ago because I knew you'd cover this. I am LIEnette, or LIEnette Island. Welcome to the long con. Yeah, you knew I would be covering this a year ago. Island, I love you. You're the best. Thank you so much for being here for a year. You undercover deep con agent. Thanks, Island. All righty, how are we doing on time? Oh, we got about 12 minutes left. Hey, we're gonna be cutting this close. That's cool. All right, peeps. Thank you so much for the support, by the way, Island. Love you. And looks like the dogs are having their morning freakout session. Employment of double standards on the part of the trial judge amounted to a violation of due process. In a manner similar to the judge in Ray Erickson, Supra, Judge Grudge interpreted and applied rules and the law in an unduly rigid manner to Hale's side of the case, while expanding, relaxing, and even ignoring them in similar context on Preston's side of the case. Double standard in determining legal sufficiency. For example, in addressing Preston's supplemental affidavit to her injunction petition, which caused a temporary injunction to be entered, Judge Grudge stated, when the court receives a petition or a supplemental petition as a matter of law, this court must accept what's alleged in the petition as true, period, end of story. Why? Because the court must do so. No choice in that. By the judge's description, one would believe he had no discretion in granting petitions involving legal sufficiency determinations. Preston's injunction petition was merely set for a hearing. The judge did not grant a temporary injunction until she filed her supplemental affidavit. It's noteworthy that in her supplemental affidavit, she specifically named Mark Feather in one of her allegations. By contrast, the judge did not accept what Hales alleged in his 2 prior motions to disqualify him as true, period, end of story. This means that he did not apply the same standard to Hales' 2 prior motions to disqualify him, which were also reviewed for legal sufficiency and contained not only allegations recognized by controlling authority as meeting the standard for disqualification, but transcript excerpts of in-court proceedings. Double standard for procedural rules. Judge Grudge employed a hyper-technical review to Shockett's notices of video depositions that were served on Preston as a witness. John Cook, in an effort to foreclose his arguments to obtain discovery necessary to prepare his case, Shockett notices were also so served before Preston's attorney was involved, and several hours of her deposition were taken before he got involved. Preston's attorney had only filed a limited appearance to argue for a continuance. This means he could not permissibly file a motion for a protective order, nor did he. Yet, not only did the judge permit ambush by allowing, over objection, Preston's limited appearance attorney to make unauthorized and unnoticed arguments to exclude discovery items and limit the taking of further depositions, he also allowed Preston's attorney to make unauthorized and unnoticed arguments about discovery directed to a third-party witness whom the attorney did not even represent. And this, if you saw the show where we went over that hearing, or you've been watching the shorts that I upload, that was the hearing I lost my shit on. The judge was literally the LIEnette's lawyer, his only purpose was to ask for a continuance of the hearing. He had a power of attorney that limited him to only talking about that. But the judge allowed him to talk about everything else. And that really annoyed the shit out of me. And I lost my cool a few times. Shockett's notices of taking video depositions included all the information required, except that the actual name of the videographer did not appear in the notice as it was unknown. Nonetheless, the error was waived under Rule 12, 330D1, as Preston, pro se at the time, appeared for the deposition and is held to the standard of a reasonable, competent attorney. See, that's the thing. I've seen people going, yeah, but he didn't do it properly. The anti-Hales group, but he made this mistake. He didn't do it properly. Well, if you don't do something properly, if you don't get proper notice, you don't appear. If someone doesn't serve you with something properly, you don't have to go. And if there was a violation of the notice, LIEnette didn't have to go, but she went, and the act of her going waives that deficiency, saying, okay, I know your notice is deficient, but I am making myself available and appearing anyway, despite the deficiency. I'm overlooking the deficiency and I'm going to do this. But she's not a lawyer. She was acting as her own lawyer, and you are held to the standard of a reasonably competent attorney. So this is it. She's waived any right to complain about insufficiency of the notice of the deposition. All right. Now I'm getting upset again. I need to get back to Zen. Judge Grudge selectively overlooked Rule 12, 330D1 and gave himself leeway to seize on the technical omission of the videographer's name in the notices, again, which were waived in any event, condemning petitioner's deposition as a video depo that was not in conformity with the rule, which then became a mantra throughout the rest of the proceeding, as well as being mentioned in the order. The judge's critical comments in front of Hales' use of Preston's video deposition makes it apparent that the judge disapproves of Hales earning income with his YouTube program. When Shockett wanted to show the court some excerpts from Preston's deposition to make it clear why he needed additional time for Preston's deposition, Judge DeThomasis looked at him incredulously and said, "So now you want to disseminate it in court, a portion of the video?" And again, I really lost my. I think it was a short I uploaded 2 days ago. Was when I lost. That's the point when I really lost it. I mean, that's the point. That's the point of depositions. You publish them in the court record. That's what you do with them so that you can use them to impeach the witness. On the other hand, when applying the rules of procedure to Preston's side of the case, The judge was not at all rigid or technical. After allowing Preston's limited appearance attorney to make unauthorized and unnoticed arguments, to exclude discovery items, to prevent the taking of further depositions, and to argue about discovery directed to a third party whom the attorney didn't even represent, the judge did not deem these as transgressions. Rather, he merely dismissed these acts by saying that it will be remedied when he files a notice of appearance, and the court will acknowledge it. And notwithstanding that no motion for protective order had been filed on Preston's behalf to limit or terminate further taking of her deposition, the judge stated that he would not permit her to be deposed further. Well, prejudgment and expression of bias directly against Hales. Judge Grudge, sua sponte, again, by his own authority, by his own power as a judge, considered the standard set forth in a rule on protective orders, and then, on nothing more than speculation and allegation, denied Shockat the ability to conclude Preston's deposition. In doing so, prejudged the issue and perhaps the case on a summary basis. And having it published in a case involving cyberstalking that's now gone on since September, how is that not, the consequence of disclosing that video on YouTube, not bad faith, or considered in a manner that would be reasonably considered annoying or embarrassing or unreasonably oppressing the deponent? And again, that's also this. That's all I lost it there on a short. It's like, if you don't want to be embarrassed or annoyed, then don't act in an embarrassing and annoying manner during your deposition. Simple. Is on video broadcast for the entire world to see that reasonably caused embarrassment, humiliation, a potential danger, and at least there's allegations of that. As is clear, the judge impermissibly shifts the burden to Hale's side of the case with regard to the continuation of Preston's deposition to establish why it should be allowed or continued, when the burden should have been on Preston. So yeah, instead of forcing and he not even allowing Jeremy's side to explain why it should have been allowed or continued, he should have been asking Preston, why should you not be forced? He should have been making her prove why she shouldn't have been forced to continue the deposition. When the burden should have been on Preston, had a motion for a protective order even been filed on her behalf to show why it should not be allowed. In doing so, he prejudged the issue based on speculative potential for a problem and elevated the omission of the videographer's name in the notice to cast generalized negative aspersions on Hales' counsel. The court perceives the totality of those circumstances and increasing the potential for additional potential harassment and or violation of the rules of the court, increasing possibility of violating terms of injunction, redaction process. The video depo notice should have been in conformity, and what appears to be a continuation of this behavior and arguably enhanced increased behavior that is troubling to this court. Well, more importantly, the court's prejudgment denied due process to Hales by prohibiting the continuation of Preston's deposition when she had not yet been questioned about her supplemental affidavit, which is what finally triggered a temporary injunction to issue. The following comments made by Judge Grudge revealed his bias against Hales because of how he earns a living. The result of that is that you got video footage for your client to publish and to make money on. Next, his main source of income is monetizing YouTube. Next, your client has now monetized the postings of unredacted court proceedings on 11/29 and 12/6, resulting in pause, a lot of collateral problems directly caused by them. Next, so that another consequence of there being additional time, and now what I'm hearing this morning is that a depo has been provided on YouTube. And then regarding the judge's overbroad ruling on sequestration prohibiting unsworn parties and unknown witnesses to discuss the case, he said that on March 1, the court will start with conducting an inquiry as to who spoke to who and will issue sanctions, including exclusions. All right, a judge's personal bias is a proper basis for disqualification. When a judge has prejudged a case without allowing the opposing party to present argument, denying due process, and issuing gratuitous prejudicial remarks, disqualification may be warranted, says this case. Of significance here, a judge should disqualify himself or herself in a proceeding in which the judge's impartiality might be reasonably questioned, including, but not limited to, instances where the judge has a personal bias or prejudice concerning a party or a party's lawyer. It was in noting in another case, it was understandable that a client would have a well-founded fear that the judge would be impartial after discovering the judge's antipathy towards his lawyer. Another case held that an indication of a bias, which may create a party's fear of not receiving an impartial hearing, There is no appreciable difference between statements directed towards the petitioner and towards the counsel. There's another case where granting a writ of prohibition to a party where the judge found the party's attorney to not be credible. Yeah, so just even saying I don't find you credible to a lawyer can be grounds for getting a judge kicked off of a trial. And finally, another court case noting the party moving to disqualify is entitled to enter the courtroom with confidence that she will receive a fair trial. In light of the foregoing, there should be no question that Judge DeThomasis should disqualify himself from this case. Wherefore, Jeremy B. Hales, having met all the requirements for bringing this motion, respectfully requests Judge Craig DeThomasis disqualify himself from proceeding further in this case, in this cause, and that another judge be assigned to this case, together with any further relief this court deems just and equitable. And here's all the statements. The certificate of good faith, special request from all counsel for blanket disqualification from all cases in which attorney Mark Feather, Randall Socket, and so this last little part is basically saying all of these lawyers want the judge to be disqualified from any case they're working on. Excuse me. The final bit of this is right here. And this is brutal. This is them literally, as I just said, they're wanting the judge removed from any case they're dealing with. All of these lawyers. Respondents counsel Randy Shockett, Doreen Ingalls, and Mark Feather Esquire hereby certify that the instant motion and the standards set forth herein are made in good faith. When a judge reasonably concludes that his impartiality might reasonably be questioned because of a personal bias or prejudice concerning a specific lawyer, the Florida Code of Judicial Conduct compels the judge to disqualify himself. This logically requires blanket recusals, even though there are no published rules to implement this provision of the code. Holt v. Sheenan. Furthermore, given the judge's extreme personal bias against Mark Feather has now clearly extended to attorneys Randall Shockett as well as Doreen Ingalls, through the case, blanket disqualification from all cases in which attorneys Mark Feather, Randall Shockett, and Doreen Ingalls appear before him as of today and going forward without limitation in the future is likewise requested and appropriate. There we go. Done, signed, sealed, delivered, and there's a bunch more affidavits. And that is the end of the reading. Let's take that out. Whew, I'm convinced. I don't know how or why, other than just being butthurt and not being told that you're not part of the case anymore. The judge didn't like that, so he denied that. He denied this third motion, which then led them to file the writ for prohibition that's being heard now, and it could take months. It could take 5 months, 6 months, or a year before the higher court rules on whether Judge Grudge should be removed from the case or not. Vince Clortho says, how much do you think just this document cost, JH? That was 33 pages, and there was a lot of going back through records and research. I'm trying to think if someone asked me for an estimate of that. 33 pages with the research, I'll say 5 hours of research. 33, 30. I'm doing some lawyer math here with a calculator. I'll say 38 times 400. If you asked me to do that, I would give you an estimate somewhere between $12,000 and $15,000. That's that. Reading what I just read and probably the research that had to go into that, I would say between $12,000 and $15,000. But I'm higher priced. I don't know what Ingalls' rate is. Let's say even I have no idea what her background is, but if someone was maybe a lawyer with 5 or 10 years experience, you might be able to half that. So we'll say, $7,000 to $8,000 for a newer attorney, and upwards for someone with a lot of experience and a lot of specialization, it could be $20,000. So yeah, if I did it, my billing rate is $400 an hour. God, I wish I got 400 an hour. That'd be awesome. But yeah, I would guess 38 hours to put something together like that. Yeah. Well, I make my boss rich. Not me. Oh no. When a lawyer says this is their billing rate, that doesn't necessarily almost never go out unless they're like a sole practitioner, but still they have to pay the lights and the bills and everything. Typically, with someone who's like a partner level, a third will go in their pocket, a third will go to be spread out amongst the partners, a third will go to the firm. If you're on a salary, it just goes to pay the office's bills. Yeah, I do not get paid $400 an hour. That would be fucking awesome. That would be fucking awesome. I would love that. I wouldn't be here right now. I would be doing that. I would be finding some work to do. So yeah, that's just an estimate. So anywho, that brings us to an end here. We've got to wrap this up. You got things to do, and you've all got places to be as well. Let me see where we can send you, and then I'll tell you what we're going to be doing the next week, and then we'll let you go. Meeting adjourned. Let's see. Where do we want to send you guys to? Let me shmee. It's Friday night. See, and I'm very happy that there was 519 of you here. Friday nights are busy on YouTube. You guys can be anywhere doing anything, watching anybody. And I'm so thankful that you chose to be here with me. And we picked up 17 new subscribers doing this. I love you guys. Please, if you haven't, I invite you to hit the subscribe button and come and join us as we continue to do these things. All righty. Going to live. What the Hales? Third motion. Go into customization. Go into redirect. And who is doing what? Chrissy Mayer, Twitter is outraged at Brittany Venti's body or something like that. Who would be outraged at that? That would be insane. Let's send you over to Lawn Lumber. Why not? He's doing his Friday night frenzy. So we shall send you over there. All right. That's looks like that's what we're doing. We're sending you on over there. They started a long time ago. Okay, folks. Yes, I agree with you, KY. I agree with you completely. All right, what's going to be happening here? We're going to send you over to Rob at Lawn Lumber, and then Monday we'll be doing the update on the bridge collapse, the Key Bridge collapse in Baltimore. The latest news. I'm trying to maybe get together at least a couple of people on a panel to do that, to just sort of dispel things. I'll update the news, then we'll take questions and answers from you people, just to see what you're all thinking about it. Tuesday, so we'll probably do the Aguilar Mendez part 2 of the federal lawsuit against the St. Johns County and the law enforcement officers involved in his horrific deal. Could be more Hales on Wednesday. I'm not sure. Thursday is retro trial day, where we're going to be looking at the Hartung case, the alleged witchcraft ritualistic murder case. There wasn't any ritual or witchcraft in the first day of the hearing. We'll have to keep our hopes up. All right, folks, that's it. Thank you so much, mods, for being here, and thank you so much for the support chat. Thank you so much for being respectful of each other and your differences of opinions. And I'm grateful for all the gifted memberships, the monthly memberships, the chats that come in. Thank you. Let's all go over to Rob over at Lawn Lumber and say hi, shall we? Take care. We'll see you all on Monday morning at this regular time. Until then, Law Racks and peace out, everybody. Enjoy yourselves. Say hi to Rob.